Hello. My latest video blog is to do with implied obligations on the part of bill of lading holders to the shipowner, and it is entitled, "My charter is bust. Who else can I sue? Can I get my freight or my demurrage from the bill of lading holder?" Well, we shall see. So, various possible liabilities. There's the indemnity for loading undisclosed dangerous cargo, which is imposed on the shipper at common law and is also, in a slightly modified form, imposed by Article 4, Rule 6 of the Hague Dispute Rules. But what I'm going to be talking about is the potential for recovering unpaid freight or outstanding demurrage or detention claims. If you're going to make such a claim against the bill of lading holder, you've got to find some provision in the bill of lading, which is a separate contract, which makes the bill of lading holder subject to obligations in the voyage charter. Or it could be a time charter. Sometimes the bill of lading will incorporate the provisions of a time charter. But we're going to proceed today's talk on the assumption that it is a voyage charter which has been incorporated. So you're going to see if there's any link between the bill of lading and a charter party. Is it an incorporation of the terms of that charter party? If you've got words like incorporation of all terms and conditions on the front of your bill of lading, and you are going to bring in all the terms which are germane to the carriage of the goods, and those will then be written into your bill of lading contract, and that will bring in freight and laytime and demurrage provisions. But the second stage in that is that some of those provisions will be rejected as insensible if the wording in their charter party wording doesn't make sense in the bill of lading context. For example, the wording of the incorporated charter clause may be specifically referring to a liability of the charterer. This is what happened in the Miramar. You've got an incorporation of all the terms and conditions of the charter party. That would bring in the demurrage provisions, but then if you look at the demurrage provisions of the charter party, it says charterer to pay demurrage. Well, that has to be rejected. It's insensible. It doesn't make any sense in the context of the bill of lading contract. So in that case, there was no personal liability of the receiver for the outstanding demurrage. The lien on cargo could still have been exercised to obtain payment of that demurrage, but although it had been exercised at some stage, it hadn't been exercised for a sufficient amount. There was still sums due. Couldn't be recovered from the bill of lading holder. If, on the other hand, the wording is something like demurrage to be paid, or more commonly, freight to be paid, that is not insensible. That will be, it's not specifying who is doing the payment. That will go into the bill of lading contract, and that will make the bill of lading holder subject to that liability, whether it be for demurrage or for freight. A slight little teaser which I should just throw out is that you might get something like incorporating words which say all terms and conditions of the charter party dated such and such, including the demurrage provisions. And I would say that the specific reference to the demurrage clause means that that demurrage clause would come into the bill of lading, and that the wording of the charter party demurrage clause would have to be manipulated so as to make it a liability which would be imposed on the bill of lading holder as well. I suspect you don't see many types of incorporation like that outside my exam papers. Okay, that's express obligations. Something being brought in from the charter party through words of incorporation in the bill of lading, terms from one contract being brought into another completely separate contract. What about implied obligations? Are there any implied obligations on the bill of lading holder regarding loading and discharge? Well, the Spiral C raised this issue. Now, in the Spiral C, the sort of similar issue to the Miramar, it's outstanding demurrage. Is there any obligation on the shipper to load and discharge the vessel within a reasonable time? Now, the demurrage provision, which was in the charter party, which was being incorporated, said that the charter was to pay demurrage. So there's no express liability for demurrage which is being imposed on the bill of lading holder. What about an implied obligation? Well, Court of Appeal said, well, if there is an implied obligation, the shipper's obligation would be to load within a reasonable period of time, but they wouldn't be liable for failing to discharge within a reasonable time. That implied obligation would fall on the receiver, person at the other end. So far, so good. But is this always the case? You have to work out actually which party to the bill of lading contract has actually undertaken to perform the loading, stowing, and discharging of the cargo under the contract evidenced by the bill of lading. And the default position is that it is the carrier who undertakes to do these operations. Now, that default position can be modified by clear contractual provisions, and examples of that are the free in, free out clauses, which you see in cases like the Jordan 2, and which have an important bearing on the ship owner's ability to incur no liability in respect of cargo which has been damaged during the loading operations, the stowing operations, or the discharging operations. The ship owner can say, if you look at the contractual provisions in the bill of lading, usually by incorporating the terms of a charter party, somebody else, whether it's the charter or the charter and the shipper, the charter and the receiver, somebody else has undertaken to do their services, not me. So I'm not liable things if the cargo gets damaged as a result of the way in which the cargo is loaded or stowed or discharged. But a clause that the bill of lading holder is going to be liable for payment of stevedoring services, or the charter is going to be liable for paying for the stevedoring services, doesn't necessarily mean that they are actually undertaking to load, stow, and discharge. It depends on the terms of the contract. And it's perfectly possible to have a contract which says that it's the carrier who, or the ship owner in the context of a charter party, carrier is going to perform loading, stowing and discharging, but the person who's going to select the stevedores and pay for them is the charterer. And this is exactly what we get in a recent case at the beginning of this month called Seamaster Shipping versus the Arab Banker, a decision of His Honour Judge Pelling, Queen's Counsel, who is sitting as a judge of the High Court. You've got a Miramar situation. The demurrage clause in the incorporated charter party is referring to charterers paying demurrage. So no way are you going to get an express liability on the part of the bill of lading holder. The owners were arguing that there were two implied terms that could make either the bank, who were probably the original shipper, although it's a little bit clear how they feature in the story, and or the receivers liable, at least for something. The first implied term was that they would take all necessary steps to enable the cargo to be discharged and delivered within a reasonable time. The second one is slightly different. It's to discharge the cargo within a reasonable time. So I'm going to take it in the order in which His Honour Judge Pelling took it. He looked at the second implied term, which was being argued for by owners first. And he then turned to what the charter party said. Clause 10, cargo is to be discharged free of expense to the vessel. Clause 11, stevedores at discharging ports are to be appointed and paid for by the charterers and receivers. Appointed and paid for. But there are additional words in Clause 11. In all cases, stevedores shall be deemed to be the servants of the owners and shall work under the supervision of the master. So this makes it clear that actually we are not departing from the default position as regards responsibility for loading, stowing and discharging, or at least certainly as regards discharging. Owners are going to be responsible for discharging, but the charterers are the ones who are going to appoint the stevedores and pay them. And this is made clearer by another clause in the charter party, clause 46, which says that stevedores' damages, if any, are to be settled directly between owners and stevedores, but charterers to assist owners at their utmost. Master to notify if possible these damages in writing, latest 48 hours after occurrence of stevedores, but owners to remain ultimately responsible to settle same with the stevedores. That again is something which is pointing to owners taking responsibility for the operation of discharging. So if you look at the contractual provisions in this charter party, although the charterers are going to appoint stevedores and pay for them, they are not undertaking to discharge the cargo. That is something which owners are doing. Now, when we come to the first of the two implied terms, to take all necessary steps to enable the cargo to be discharged and delivered within a reasonable time, owners put forward the argument that delivery of the cargo was a collaborative process, and they sought to get an implied term relying on what Lord Blackburn had said in Mackay and Dick back in 1881. And his lordship said, "I think I may safely say it as a general rule, that where in a written contract it appears that both parties have agreed that something shall be done, which cannot effectually be done unless both concur in doing it, the construction of the contract is that each agrees to do all that is necessary to be done on his part for the carrying out of that thing, though there may be no express words to that effect. What is the part of each must depend on the circumstances." However, His Honour Judge Pelling said that neither delivery nor discharge depended on this process of collaboration which Lord Blackburn was referring to. The only collaborative element was the receiver's obligation to appoint stevedores. That was under clause 11. But that in itself didn't make it necessary to imply a term. It wasn't necessary or reasonable to do that. First of all, the express obligation to appoint was absolute in its terms. So, what's the point of having an extra implied term? And secondly, there's an express agreed contractual mechanism in clause 20, which applied in the event that discharge was delayed by the failure of the defendants to appoint stevedores. So they've already contemplated what's going to happen in that event. So, just because you've got a clause in the charter which comes into the bill of lading, which says that charterers and or receivers are going to pay for, appoint the stevedores and pay for stevedores, that doesn't necessarily mean that they have undertaken the operation of discharge. You've got to look closely at the other contractual terms and see whether the default provision that it's the ship owner who is doing the discharging, he's responsible for discharging, whether that has actually been displaced by some specific contractual term. In this case, it wasn't. So, thank you for your attention, and I'm sure there will be another short video blog coming along before too long. Goodbye.